part, we will analyze the Contract Act from the angle of performance of a contract. Here, we shall mainly discuss about who are liable to perform a promise, who are entitled to demand the performance of a promise, who should fulfill the promise if it's a joint promise, and then what are various modes of discharge of a promise. In any contract, the basic requirement is obviously each party has to perform his part of the promise and demand other party to perform other party's part of promise. The very important point is not only the promisor has a duty to perform, but say after the death of promisor, his representative shall also have a duty to perform that particular promise unless a different intention is appearing from the contract. Now let's see who are the persons who are liable for performance and who are entitled to demand the performance of a promise. This section 40 and section 42 of the Contract Act, which gives us these provisions. The law says these are the persons who are liable for performance, that is promisor himself, agent of the promisor. In case it's a joint promise, then any of the several joint promisor, he is liable for performance, and as we have discussed earlier, in the event of the death of the promisor, the legal representative is also liable for the performance, meaning thereby that promisee may demand any one of these to perform their part of promise. Now let's see who are the persons who are entitled to demand this performance. Obviously, promisee can always demand the performance. Agent of the promisee can also demand the performance. In case promisees are more than one, then all the joint promisees together can demand the performance. And in case of death of a promisee, legal representative of the promisee can also demand the performance. Now let's understand some more issues about performance of a joint promise. When two or more persons have made a promise, then what all are the requirements related with the performance of this joint promise? When two or more persons have made a joint promise, then section 42 says that unless a different intention is there in the contract, following are the persons who shall be responsible to fulfill that promise. First of all such persons shall be liable for the performance during their life. After the death of any of the promisor, his representative shall be liable with other surviving promisors. And say after the death of all the promisors, the representative of all the promisors jointly shall be liable for the performance. Now let's see how the performance of a joint promise takes place. The rule is the promisee may compel any one or more of joint promisors to perform the whole of the promise. The very important idea is it is not necessary for the promisee to ask everybody of the joint promisor to perform the promise. He may choose any one or say more than one of the joint promisor and ask them to perform whole of the promise. Now what will be the situation of the joint promisor who has been asked to perform the promise? This joint promisor may compel every other joint promisor to contribute equally with himself to the performance of the promise. The point is this: promisee is not required to go to every joint promisor individually and ask them to perform. He may decide to ask the performance from any one of the joint promisor. It is for this joint promisor to compel others to join himself for the performance of whole of the promise. To take the earlier discussion forward, what will happen when any one of the joint promisor makes default in such contribution, promisee has asked one of the joint promisor to perform the promise. This joint promisor in turn has asked other joint promisors to contribute in the performance of this promise, and any one of the joint promisor has defaulted in contributing. Now what will happen? The law says if any one of the joint promisor makes default in such contribution, remaining joint promisor must bear the loss arising from such default in equal share. This is what section 43 is prescribing. This is called the rule of joint and several liability of the joint promisors. The liability of joint promisors is joint and several. After discussing the rules regarding performance of a promise, and more particularly performance of a joint promise, now let's discuss what will be the effect when a promisee refuses to perform the promise. Section 39 of the Act discusses effect of refusal of a party to perform his part of promise, and section says that when a party to a contract has either reduced to perform or has disabled himself from performing the promise, then the promisee may put an end to the contract then and there itself. However, if the promisee has signified his acquiescence in the continuation, then the contract will not come to an end. The promisee may signify his concurrence either by words or even by conduct, and in that case the contract will continue. Let's try to understand this by two examples. The example is basically based in a situation where a singer has contracted with a theatre manager to perform in theatre for a particular period, 2 weeks to every week 2 months. On one particular day, the singer absents himself from performance. The theatre owner can cancel whole of the contract. This is one way of dealing this situation. Now another possibility is this: the singer has defaulted on 6th night, but then the theatre manager has agreed that he can continue singing from 7th night onwards. In this case, the theatre owner, the other party, has signified that he wants continuation of the contract, and later on he cannot cancel the contract on the ground that on 6th night the singer has failed to perform his part of promise. The other party has now conveyed his interest in the continuance of contract, and now the contract cannot be cancelled. Now come to another aspect of performance, that is offer to perform, or in other words attempted performance, tender of performance. What will happen when one party has offered to perform but other party has refused to accept this offer of performance? The law says where the promisor has made an offer of performance to the promisee and this offer of performance has not been accepted by promisee, then the promisor shall not be responsible for non-performance, and at the same time his rights under the contract shall remain alive. He will not lose his rights under the contract because he has offered to perform but the promisee has refused to accept the performance. In such case, the offer of performance must fulfill certain conditions as follows. The offer of performance made by promisor must be unconditional. It must be made at a proper time and place. The promisee should have a reasonable opportunity of examining, ascertaining, deciding that promisor is actually able and willing then and there to do what is promised. One party has simply offered to perform without giving other party to assure itself that whether the first party shall be actually willing to perform the promise or not, this offer of performance is not a good offer of performance. And finally, this offer of performance must be for a whole of what the promiser is bound to do. Any offer of only part performance is not a valid offer of performance. A related condition in this case, that if the offer is actually an offer to deliver something to the promisee, the promisee must get a reasonable opportunity of examining that the thing offered is very same thing which promiser is actually bound to deliver. If this condition is fulfilled, then only offer of performance shall be treated as a valid offer of performance. The next aspect of performance we need to examine is time and place of performance. Section 46 of the Contract Act discusses the situation when, as per the contract, no time has been specified for the performance and no application is also required to be made for performance. In this case, the law says the offer must be performed within a reasonable time. In the contract itself, no time has been specified. No prior application is also required to be made for performance. In such case, the performance must be made within a reasonable time. That is what Section 46 is prescribing. Now, what is a reasonable time? It's a question of fact. Depending upon facts and circumstances of every case, the reasonable time is required to be decided. Section 47 discusses the situation where the time of performance is specified in the contract itself, but no prior application is required to be made. In such case, the law says the promiser is required to perform the promise at any time during the normal business hours on the day which has been specified as a day in the contract for the performance of the promise. This performance should be made at a place where the promise is required to be performed as per the terms of agreement. Say for example, when there is a promise of delivering the goods by Mr. A to Mr. B at Mr. B's warehouse on 1st of January, the place of performance and the date of performance has been specified in the contract itself. In such case, Mr. A is required on 1st of January to bring the goods at the B's warehouse during office hours, during normal business hours. If the goods have been brought at the warehouse after the normal business hours, then it is not a valid performance by Mr. A. Then Section 48 specifies a situation where promisee is required to make an application for the performance at a particular place on a certain date. The law says in such case, it will be for the promisee to apply for the performance at a proper place and during the normal business hours on the day specified in the contract. Again, what is a proper time and place? It's a question of fact depending upon facts and circumstances of every particular case. Section 49 covers a situation where a promiser is required to make an application to the promisee to finalize the place of performance of the promise. The section says that where as per the terms of contract, the promisee is not required to make an application for the performance, and at the same time, the place of performance has also not been fixed by the contract. Then, what will be the place of performance where the promiser is supposed to perform that promise? In such case, as per the law, the duty of promiser shall be to apply to the promisee to ask from the promisee that a reasonable place may be decided for the performance of promise, and the promise is required to be performed at such place. Say for example, there is a contract between A and B where A is required to deliver something to Mr. B on a particular day, but the place of delivery has not been specified. It shall be the responsibility of Mr. A to apply to Mr. B for appointing a reasonable place for as the place where B would like to receive that material, and in such case A is required to deliver the material at such place which has been specified by Mr. B. The last provision in the series of time and place of performance is section 50 of the Act, which simply prescribes that if nothing has been specified in the contract, then the promise may be performed at any time in any manner which the promisee prescribes, and this will be treated as a valid performance. Say for example, Mr. Raja has borrowed some money from Hari and promised to pay it back after 1 month. On the date of repayment, Hari accepts certain goods from Raja in lieu of his date. Now the Raja has validly performed his promise. His performance is in the manner which promisee has sanctioned. Let's now understand another concept related with the whole issue of promises, that is the concept of reciprocal promises. First of all, we will understand what exactly are reciprocal promises, and then we will discuss certain rules given by the Act related with the reciprocal promises. Section 2 clause F of the Act defines reciprocal promises as set of promises which form consideration for each other. These are two promises and one is forming consideration for another, and both of these together shall be called reciprocal promises. Say for example, Raja promises to do or not to do something for Mr. Hari, and Mr. Hari promises to pay something to Mr. Raja for this. Both of these promises are reciprocal. Now let's see what are the rules given by the Act regarding performance of the reciprocal promises. The very first rule is given by section 51, which deals with simultaneous performance of the reciprocal promises. The section says, where the reciprocal promises are of the nature that they are to be performed simultaneously, no one party is required to perform his part of promise unless the other party is ready and willing to perform his part of the reciprocal promise. Say for example, two parties have contracted that A shall deliver goods to B and B shall make the payment to A normal sales kind of contract. Now A is not required to deliver the goods unless B is ready and willing to pay the money, and B is also not required to pay the money unless A is ready to deliver the goods on payment. The next rule regarding performance of reciprocal promises has been given in section 52 of the Act, which says that where the order of performance of reciprocal promises is expressly specified in the contract, the promises shall be performed in that order only. However, where the order of performance has not been fixed expressly, then these promises shall be performed in the order in which the nature of transaction requires. Say for example, when there is a contract for construction of a house, B has promised that he will construct a house for A, and A has promised that he will pay some amount for this to B. Now obviously in this case, first B is required to construct the house, and then only A is required to make the payment. So this is the rule regarding order of performance of reciprocal promises. Section 53 deals with a situation where one party prevents another from performing his part of promise. Section simply says that if one party prevents another to perform his part of promise, the contract becomes voidable at the option of this other party, the party which has been so prevented, and this other party shall be entitled for compensation also. A very simple example can be where two parties have entered into a contract where second party B has promised to do some work for first party A, and A has promised to pay some money to B in lieu of this. Later on, A stops B from performing that work. The contract shall become voidable at the option of B, and if B decides to cancel that contract, B shall be entitled to claim damages also from Mr. A. So, Section 53 is prescribing what will be the effect of one party preventing another from performing his part of promise. And then Section 54 gives us a rule regarding a situation where there is a default in performance of a promise which was required to be performed first. Section says, when a contract consists of reciprocal promises and it is of such a nature that one of them cannot be performed till the other promise has been performed, and the promisor of that other promise fails to perform the contract, the other party other than which who has failed to perform, shall be entitled to claim damages from the failing party, and failing party cannot claim performance of the reciprocal promise from other party. The promise which was required to be performed first, its promisor has failed to perform this. Now this person cannot claim other party that they should perform their part of promise. Apart from this, he will be liable to pay compensation to other party also. Say for example, two parties have entered into a contract for sale of something which are required to be delivered next day. Other party promises to make the payment after a month of delivery. First party A fails to deliver these goods. Very logically, he cannot claim that other party should make the payment, and at the same time, other party may on the contrary claim the damages from first party A for failure to perform his part of promise. After discussing rules regarding performance of reciprocal promise, let's discuss another situation related with the performance of promise, that is appropriation of payments. Appropriation of payments is basically a question related with a situation where a debtor owes a number of money to his creditor, and when he makes only some of the payments, the question arises how these payments should be adjusted against the series of money which is due to other party. Section 59, 60 and 61 of the Act gives three rules regarding appropriation of payments. Section 59 talks about a situation where the party making the payment has indicated in lieu of which date this payment is being made. So where date to be discharged is indicated, then this situation is governed by Section 59. Then Section 60 talks about a situation where the date to be discharged is not indicated, And finally, section 61 covers a situation where neither of the party has appropriated this payment to any particular date, then what shall be the rules regarding application of payment? In next slides, we will be discussing these three sections in little bit detail. Example, A owes to B a series of dates, one of them being a sum of rupees 50,000. B writes to A and asks for the payment of this particular date. Now A has paid rupees 50,000 to B. Here the circumstances are conveying that A is making a payment towards discharge of that date which has been demanded by B, that is rupees 50,000, and now this payment has to be adjusted against that 50,000 date only. So the first rule regarding appropriation of payment by section 59, when the date to be discharged is indicated by the act of the parties or by way of clear instructions. Now section 60 is talking about a situation which is opposite to what we have discussed in the earlier slide, section 59. In this case, now the date to be discharged is not indicated. Section says, where dater has also omitted to indicate against which date he is making this payment, and circumstances are also not clearly conveying the idea that this payment is for a particular date, then this will give a discretion to the creditor and he may adjust this amount against any lawful date which is already due to him at that particular time. Even if recovery of this date is already time barred, still creditor can adjust this payment against any lawful date, whatever he thinks. And then the next situation in this case is application of payment where neither dater has indicated against which the payment is being made, nor creditor has appropriated it against a particular payment. So law says, where neither party makes any appropriation, the payment shall be applied in the order of time. The first date shall be adjusted first, next date shall be adjusted next, like this. Even if the first date is already time barred, but still the adjustment shall be made based on order of time. In this case, another situation may arise. The dates based on order of time are of the equal standing. Say for example, two dates have been taken on the same date, then the payment shall be applied in discharge of each of these equal level dates on a proportionate basis. And this completes our discussion regarding various issues related with the performance of a contract. Thank you.